Hello and welcome to the next in the series of videos from the Wilkes Partnership. I'm Helen Smart, I'm a solicitor in the corporate and commercial team, and today I'm with my colleague Rick Smyth, who's a partner in the corporate team. Today we're going to be discussing some of the issues that shareholders and directors have found during the lockdown crisis and coronavirus crisis, and coming out of lockdown, how they can start to rectify those issues so that they won't affect them in the future. Obviously, Rick, we know that a lot of the shareholders and directors so far have been focusing on day-to-day operations of their business and trying to keep things going during lockdown and the coronavirus crisis. And that's ranged from getting government loans, using the furlough scheme, just dealing with day-to-day operations and how things are changing with the government guidance that's coming out. What issues have shareholders and directors found as a result of coronavirus and the lockdown?
Well, I think probably there's a number of issues that we've been talking to our clients about, and they break down into kind of three main areas really. The first of all is that this pandemic has highlighted to many shareholders the real vulnerability of having all their eggs in one basket. And it's highlighted the need to ensure that people have proper corporate structures which protect both individual businesses and their assets. We've also seen that there's been some historic tax planning practices which have made a lot of sense in the past, but now expose their shareholders, and particularly shareholder directors, to risks which they previously hadn't really thought about that much. And it's also highlighted something which we as lawyers obviously highlight regularly, which is the need for proper corporate governance and making sure that the relevant documentation is in place to record all the decisions that are being made should the worst ever happen.
Yeah, and taking the first of those, what steps can people take to separate assets and investments within businesses?
Oh, blimey, there's a question. There are many different ways in which people can do that. Probably the most common way that we see is people putting in place a group company structure. So this is where they would set up a holding company and possibly, which is the which then wholly owns the trading company, and then dividending out all of the assets, the non-trading assets, free cash, everything which isn't necessarily required to run the business. I'd say we're seeing a lot of interest in people wanting to do that. The benefit of that, of course, is that it allows people to protect those assets so that if the trading business itself hits difficult times, then those assets are away from the business, and provided they followed the appropriate structures and the appropriate, they've got the governance right when they do that, they stand a reasonable chance of being able to protect those assets should the worst happen to the business. Secondly, we're seeing that people are genuinely interested in separating their businesses completely. Demerge, we call them. In very simple terms, it's where you may have a property trading business, for example, or property investment business, and then a straightforward, trading business, and people realizing that if the trading business goes down, all of those property assets are going to be liable to be, used to support the to deal with the insolvency. So we're quite often seeing people looking to use the capital reduction process, which is brought in by the 2006 Act, very simple, as a way of properly separating those two businesses out. And provided they go through the right process, again, that works very well. It's tax neutral, you can get clearance for it. It'll be interesting to see actually how the old Section 110, which involves a liquidator as a surefire way of making sure that what they are doing is done all above board. Whether that comes back into fashion actually, because it's fallen away with the more simple capital reduction process. Yeah. We think that protection, is valuable. And the third that we're seeing people to really look at is in relation to retention of staff. Obviously, when cash is tight and people are struggling to pay bonuses and to keep good quality people, that means that two things happen really. Firstly, good people become disaffected, and secondly, those businesses which are strong take it as an opportunity to go on a recruitment phase.
Yeah.
So one of the ways which we see people incentivising those people where they can't actually provide them with cash is by offering them share options, particularly under the EMI share option scheme, which is very tax advantageous and allows the company to give people a real sense of ownership and build some real value for themselves, be part of the team. Yet it doesn't actually cost the company any hard cash in doing that. So that's what I'd say those are the main areas that we're seeing people focusing on at the moment.
And in terms of funding and loans, what are the options for people going forward? Because obviously a lot of companies have taken up the government schemes and the coronavirus related loans. Should they be looking at refinancing those or any other kind of available funding to them?
Yeah, again, I think that the commentary in the market is that a lot of people have taken these loans, and the concern there is that obviously they're going to find themselves in a difficult spot in 12-18 months with quite weak balance sheets, which is going to have a significant impact on their operating. And if that is the case, then rather than lose the business, shareholders really should start to look at some of the other options out there. I think it's fair to say that there's a wall of money out there. In terms of private equity money, in terms of some of the more equity support funds, such as people like BGF, and the government is even now talking about setting up its own support fund, similar to the old 3i fund. So I think there is going to be quite a lot of refinancing funding available at relatively acceptable terms. And people need to understand those, and if they don't know their way around those, there's accountants or other people who work in corporate finance to properly understand that before it's too late.
Yeah. And in terms of people who perhaps coronavirus has been the last straw, have already been thinking about perhaps leaving the business. Obviously, for directors and shareholders, the biggest kind of de-risk is to leave completely. Have you seen an increase in people starting to think about exit options?
Yes, I think that's right. Actually, there's definitely a generation of business owners who are out there who've survived the financial crash. They've survived a couple of recessions and are now looking at it and thinking, actually, now we want to hang up our boots and to move on. And one of the problems that will be faced by those people is that whilst there's definitely opportunity out there, and there are people who will go on and be acquisitive, and we are seeing an uptick in interest from acquisitive clients, there will be some businesses which are just quite difficult to actually sell by virtue of the nature of what they do, or because of the size, or because of the sector that they're in. And I think it's important that if people find themselves in that space, that they should recognise that there are options beyond just trade sale. I'd say that we do probably 5 or 6 significant management buyouts each year here, and quite often they're actually assisted by the vendors themselves, who put in place a sensible management team, and they sell it to the management team, and then they lend back part of the purchase price so that management team doesn't actually have to buy it. And of course, there's lots of private equity money out there as well. So there's definitely options out there. But what we would say is that if people are thinking about actually, the ultimate de-risk, which is to exit the business and diversify, then they need to start thinking about that soon, really, because these processes typically take anywhere between 12 and 24 months. And a lot of people don't realise that. They think it's as straightforward as just putting the business, hanging a for sale sign over the business, and it'll all be done and dusted by Christmas. So if people are thinking about doing that, they should really be looking at that with some focus relatively quickly.
And you mentioned that one of the issues that has come out of coronavirus for directors and shareholders is in relation to historic tax planning that has occurred. What should they be aware of in respect of that?
Yes, yeah. I mean, this is very common actually. In that a lot of accountants quite rightly provide advice to their clients and say, rather than you shareholder director pay yourself by way of salary and pay, PAYE and national insurance, why don't you pay yourself a modest salary, taking advantage of the lower tax brackets for those modest salaries, and then pay yourself by way of dividends. I'd say the majority of businesses that are in that SME sector would at least have considered this, and if not doing it. And whilst that's fine, whilst you're working in a stable business in a regular market, where things become more volatile and the business starts to fail, if you have been adopting that practice, it often comes as quite a shock to those individual shareholders that should the company go into an administration or a liquidation, quite often those administrators and liquidators are then coming back to the shareholders and asking for that money back. For the very simple reason that they paid themselves profits out of the business within the year or two prior to an insolvency, and the insolvency legislation has very strict rules about how you can do that, and most of the time they will be, they may not be quite as aware of that as otherwise should be. So we would encourage people that if they are currently doing that, that they should look at that again with their accountants and understand whether it's still appropriate, or whether it is something which they should maybe cease to do, maybe pay themselves properly, and just be aware of the fact that that money may well be coming back. And of course, it is a personal liability on them because they will be in breach of their director's duties.
Yeah. And just to finish off, have you got any parting advice for us in respect of what we've spoken about today?
Yes. I think the number one piece of advice for anybody who is struggling in any way, shape or form, or has questions, is go and get some advice. That might sound self-serving from a lawyer, but if you think the challenges is that people don't go and get advice. Quite often they can find themselves in serious hot water. Going and getting professional advice protects them personally in terms of any likely liability issues that they're going to have, personal liability issues they may have on any ongoing insolvency, and quite often, the advisory community will have solutions and advice which will allow them to circumvent their current problems and work through them. So we're conscious that people don't necessarily want to spend money on professional advice, and it's interesting actually that so much so that the government have now been talking about actually setting up a fund for SMEs to be able to go and seek to get some professional advice in circumstances on a grant basis. We're waiting to hear waiting to hear the detail on that, but that sounds like it's likely to happen. But we are here for a reason, and we do this on a regular basis, and we help businesses through difficult patches. So it's a false economy to try and do it yourself, and quite often people find themselves making the problem worse by not going and getting advice. The other thing that we would say is in SME businesses, very often things are not as well documented as they should be. People tend to make decisions not at formal board meetings and the like. That's all fine, but we would really strongly recommend that when life gets a bit tougher, have the discipline of actually taking full sets of board minutes. Make sure that you do actually have a regular set of board meetings to sit down and discuss the ongoing future of the business, the ongoing solvency of the business. because all of that is very strong evidence that that you're meeting your requirements as directors should the business subsequently get into difficulties. And of course, if you are going down that road, then the right thing to do is obviously, and you conclude that you are finding difficulty with the ongoing viability of the business, go and consult with an insolvency practitioner. A lot of these people will be there. They're happy to come and talk to you and provide advice, support, business rescue support. So people, and in doing that, you provide the perfect cover for yourself as individuals, because going and getting professional advice can never be wrong.
Brilliant. That's great. Thank you very much, Rick.
Pleasure.
If you need any advice from Rick or the corporate team, then we are all still working mainly from home, a bit in the office now, and our contact details will appear at the end of this video. Feel free to get in touch with us, and we'd be happy to hear from you. In the meantime, stay safe, and thank you for watching.
Thank you.